the labor board agent expressed reservations in his opinion as to whether the owner-operators were employees, but because this is a case of first impression before the labor board, they felt that the appropriate thing to do was to forward it on to a hearing and to let the labor board decide that issue. So the first day of formal hearing is next week, the 29th. As is typical of the labor board, it is scheduled at 1:30 in the afternoon, and trust me, by 5 o'clock nobody will be in the building. So the initial hearing is about 3.5 hours, 3 hours, and especially the first hearing, there's usually some procedural housekeeping or wrangling of some sort. So my point is, this is not the end. This is simply the beginning. The owner-operators will have the burden of going forward. In fact, they have the burden of proof in this case. And they have initially indicated 3 witnesses. Who knows what will happen as we go on, but we're looking at 2, if not 3 days minimum. And incidentally, the labor board does not say, see you tomorrow. What they will do is take out their calendar and they'll look at the hundreds of other cases they have going on, and they'll say, we have a date at the end of February, or we had a cancellation early February, but the point is this is likely to go on over several months. I don't think it's likely we would see a decision before midsummer, and it could certainly possibly take longer than that. So that's it. We're up there by virtue of the complaint that was filed by the owner-operators. We're there to defend it. They have the burden of proof, and that's really it. And as I indicated, I suspect folks probably want to know, well, where could this go? And that's beginning to get into areas where I'm comfortable. But let me say this: this is like no other case they've seen. And so it's virtually impossible to predict where it's going to go, frankly. Even the labor board agent, who's a very seasoned fellow who's been around for a long time, he had the same reaction.
Who has a contract for next year and who doesn't have a contract for next year? 1, and number 2, if you can. Number 2, if this goes on unsolved, if you will, until, let's say, the summer, how many bus drivers are we going to have on these routes? Are we going to have the owner-operators and All-Star and everybody driving these children to and from school?
Well, let me answer the first question. Virtually, and Ron may be able to give you some more detail on this, but virtually all of the owner-operators have a contract through June 30th, I believe it is, of 2012, and no contract beyond that. There are a couple of exceptions to that, but for the most part, their contracts end at that point in time. And even though they have taken they've taken actions which, frankly, I have viewed as inconsistent with their obligations under the contract, and specifically filing a complaint where they deny their status as independent contractors, they continue to operate under that agreement, and the board continues to operate under that agreement. And presumably that will continue for the current school year. And of course, the contract with the new bus company picks up for the next school, beginning next fall. So as things are set now, their contracts will expire. They're not renewed, with a couple of exceptions mentioned. And the bus company, All-Star, will pick up from that point. The labor law, one theoretical option, of course, one theoretical option is the labor board finds they're not employees and goes in the board's favor. One option is they find that they are employees, but, and I think this is certainly, if they were to find that they are employees, I think this is a likely outcome. They would say they're employees, but the labor law does not cover the provision of equipment. So one theoretical option here is that the board is entirely free to go out and contract for buses and bus-related services, but it has to take on the owner-operators as employees, sans buses, without their buses. So where does that leave us? But, without getting into a lot of detail, that is certainly an eventuality that was factored into the contracts.